Litigation dispute resolution comparative guide in South Korea. Legal framework. What system of jurisprudence applies in your jurisdiction? What implication does this have for litigation? South Korea is historically a civil law jurisdiction. Generally, South Korea's legal framework and many of its laws are derived from historical German law. However, in recent years, South Korea has aggressively embraced what are seen as the best practices and legal developments of both civil law and common law countries. In particular, South Korea has adopted a number of court practices that depart from its civil law tradition. For example, while the South Korean court traditionally followed the civil law practice of only using bench trials with question of law and fact determined by judges, in 2008 they introduced limited use of juries in certain criminal trials. The South Korean court have also begun allowing increased use of document disclosure in civil cases, although the scope of such disclosure remain much more limited than that seen in common law courts. In sum, South Korean jurisprudence generally follows the civil law principles. Thus, the statutes and laws enacted by the National Assembly are the most fundamental source of law. In addition to the codified statutes, case law plays an important role in the interpretation of laws. The case law of the Supreme Court is binding on the High Court, the District Court, and the Supreme Court with regard to that specific question of law. And in practice, the court tend to interpret the Supreme Court's finding narrowly rather than broadly. What rules govern litigation in your jurisdiction? In South Korea, law is generally classified as substantive law and procedural law. As regards civil litigation, acts, statutes, regulation, and similar on specific subject matter govern the substantive issues, and the Civil Procedure Act of South Korea, the procedural issues of a civil matter. Do any special regimes apply to specific claim? The Constitution of the Republic of South Korea states that the court shall be composed of the Supreme Court, which is the highest court of the state, and other courts at specified levels. Article 101, paragraph 2. It further provides that the structure of the Supreme Court and the lower courts will be determined by statute. Article 102, paragraph 3. In accordance with such provision, the Court Organization Act was enacted, which constituted the three-court system comprising the District Court, the High Court, and the Supreme Court. The Court Organization Act further provides for the following special court: the Patent Court for patent litigation, the Family Court for family cases, the Administrative Court for administrative litigation, and the Bankruptcy Court for bankruptcy or insolvency related cases. In addition, martial court hear military related cases. Generally, the three-instance trial system applies to litigation in South Korea, although a two-instance trial system or single trial system may apply depending on the type of litigation. Appeals against dispositions of the Fair Trade Commission and administrative appeals against decision of the Intellectual Property Tribunal are deliberated under the two-instance trial system, which means that the High Court are the court of first instance. Any lawsuit concerning the election of the President and members of the National Assembly are administered under the single court system, with the Supreme Court as the court of first instance. Which bilateral and multilateral instruments have relevance to litigation in your jurisdiction? The bilateral and multilateral instruments of relevance to litigation in South Korea are as follows: the Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil and Commercial Matters, the Hague Convention on the Taking of Evidence Abroad in Civil or Commercial Matters, the Protocol to the International Convention on Civil Liability for Oil Pollution Damage 1969, the United Nations Convention on Contract for the International Sale of Goods, and the Convention on the Settlement of Investment Dispute between States and Nationals of other states. Judicial structure. What courts exist in your jurisdiction and how are they structured? The type of court in South Korea as follows: the Supreme Court, the High Courts, the District Court, the Patent Court, the Family Court, the Administrative Court, and the Bankruptcy Court. Martial court, where military officers who are not qualified as judges hear cases, also exists for military trials. The Supreme Court has final jurisdiction over all type of cases according to the Constitution. What specialist court or tribunals exist in your jurisdiction? In South Korea, there are four specialized courts as follows. Patent Court. The Patent Court has original jurisdiction over appeals of decision of the Intellectual Property Tribunal. Its decision may be appealed directly to the Supreme Court. Thus, the court operates within a two-tier court system. The Patent Court has technical examiners who has degrees in natural science, technology, and other professionally related fields to assist judges with the technical matters of patent and utility model cases by providing consultation and expertise. Family Court. The family courts have exclusive jurisdiction over domestic relation cases, domestic violence cases, juvenile offense cases, and child abuse cases. They are equivalent to the district court. Each family court has a conciliation committee to handle conciliation proceeding and investigative officers to conduct necessary investigation. Administrative Court. There is only one administrative court which is located in Seoul. The Administrative Court has jurisdiction over tax, eminent domain, labor, and other administrative matters. An administrative lawsuit may be filed without first resorting to administrative remedies unless otherwise provided by law. Bankruptcy Court. The Seoul Bankruptcy Court, currently the first and only bankruptcy court in South Korea, preside over major bankruptcy or rehabilitation cases and provide more effective, specialized, and consistent guidance in bankruptcy proceeding. Pre-litigation. What formalities apply before litigation can be commenced in your jurisdiction? There are no particular formalities that apply in this regard. Do any pre-action protocols or similar rules apply prior to the commencement of litigation? What are the consequences of non-compliance? There are no such pre-action protocols or similar rules that exist. What other factors should a party consider before commencing litigation in your jurisdiction? A party must consider a fair amount of strategy and tactic before litigating in South Korea, including the burden of proof, legal costs, and enforcement procedures.